SJC-12003, Bryan Corporation v. Bryan, Abrano, and another.
Mr. Yurko, good morning.
Good morning, Your Honor. May it please the court, Richard Yurko on behalf of the appellant Bryan Abrano. For a moment, I want to turn the clock back just 1 year. In March of 2015, the company, Bryan Corporation, and I'll be referring to them as the company because of the confusion with names, brought this action against Bryan Abrano, his sister Bridget, and his brother-in-law. In April of 2015, after my firm appeared to defend Bryan, as it had been representing Bryan in other matters, the company moved to disqualify us because 1 year earlier, for a period of 3 months, we had represented the company in a completely unrelated matter, the Waldman action.
When was the action, your action against Mrs. Abrano et al., when was that filed?
That was filed in November of 2014, Your Honor.
And when were you retained for that matter?
We were originally retained on July 1, Your Honor, not for that matter. We were retained on July 1 by the individual defendants to deal with the situation of the father, Frank Abrano, interfering with the company. A year earlier.
Well, more particularly, I think, right, interfering with your clients being paid.
Actually, the assignment to us was to deal with the interference generally by Frank Abrano. The interception of checks that had been cut to the clients was not the focus of that retention. Basically, just to review, if you go back, well, on the motion to disqualify, we had represented the company, we had ended our representation 8 months earlier. So we believe that there was no basis for the motion to disqualify.
What was that date?
Yeah.
Pardon? I'm sorry?
When had you withdrawn from the representation?
We withdrew from the representation on July 16th or 17th of 2014, Your Honor. That's when we informed...
Oh, this is the Waldman representation?
The Waldman case. That's when we informed the company that a conflict had developed and we had to withdraw.
And the conflict was that you had now taken on Bryan.
No, Your Honor. The conflict, when we took on Bryan and Bridget, there was no conflict with the company.
How did this conflict happen? You're representing the company and now you're suing the company. So when did this conflict come to your attention?
The conflict occurred on July 15th,
Yes.
2014. On July 15th, 2014, Kim Abrano, Bryan and Bridget's mother, seized control of the company, elected a board of directors that included herself, two friends of Frank, right, and at that meeting threatened the clients that we were representing that they would not see another dime from the company.
Okay, so you were already representing Bryan in his dispute with the company over compensation.
No, Your Honor.
What were you representing him about? The fact that he didn't receive his compensation?
No, Your Honor. We were not asked to represent him on that subject. We were asked to address at the time.
To address the fact he didn't get paid. Am I missing something here? What were you advising him about starting in July 1, that he wasn't getting paid, right?
No, Your Honor. There was a pattern of conduct involving the father that consistently interfered with the company. The company, well, let me take the back. Your Honor.
Violation of the agreement, right? So-
Yes.
Right.
And on top of that, keep in mind that both Bryan and Bridget were parties to a contract in which they purchased their shares from the father. The father was an outsider to the corporation at this point in time, and he was impermissibly inserting himself.
So on the 15th of July, you decided you really were going to sue the company.
No.
No, Your Honor. On the 15th.
So where's the conflict?
Your Honor, on the 15th of July, a conflict was created by the actions of Kim Abrano, and then at that point, we had to withdraw. We had
Plus you
already
wanted to
undertaken the
conti- Why did you have to withdraw at that point? I mean, because at this point, you're still representing the company. And the question is, who's the company? Is it only the company that you represent so long as it is Bryan and Bridget? Or is it the company once the change of control happens?
Your Honor, it's not, the change of control per se is not the essence of what drove the conflict. On July 15th, we were representing the company in the Waldman action, and we were representing Bryan, Bridget, and Denon with respect to the interference of Frank Abrano. On July 15th.
Of Frank would not have been something that you would have needed to represent them on if you were just representing the company, right? I mean,
Oh, we were not representing the company.
by one, when they bring you this problem of Frank, it's because they're in control of the company, and Frank is interfering with the company.
Your Honor, we were approached on July 1 because...
By them individually, or by them as controlling the company?
By them individually.
By them individually?
In any time a lawyer is asked to represent a constituent of a company, the lawyer has to make plain who I'm representing and the
So
client.
July 1, who are you representing?
I was representing the individuals.
As well as the company?
I represented the company in the Waldman action. There was
But
no
that's when the conflict started.
There was no conflict at that time, Your Honor. Absolutely none. On July 1, the company had an agreement that said Frank wasn't supposed to be involved with the company. So its interests and the individual's interests were consistent on that question. The Waldman action, there was no conflict with anything in the Waldman action, which was an action about unpaid invoices.
Mr. Yurko, on July 1st, when you agreed to talk to Bridget's husband, the reason that he wanted to talk to you was because they weren't getting paid. And is that right? They weren't getting paid, so they wanted to broach the subject with you of what do we do about this? That's what I read from the briefs. Is that the problem that he brought to you?
No, Your Honor, that's not the problem that he brought to me. I mean, Denon Rodriguez was the treasurer of the company. If he had wanted to, he could have written replacement checks. He didn't need me to do that. What in point of fact they came to me was, this is the most recent occurrence of the interference of Frank that we have to address at some point. The telephone call included the company's outside general counsel. At no point was I asked to be adverse to the company. The people that came to me owned 49% of the company. They were 2 of the 3 directors. They did not ask me to consider an action against the company, and it's remarkable that it's suggested, because there's nothing in the record that suggests they asked me to be adverse to the company, that it's intimated that in a conversation with the general counsel of the company, that somehow
Well,
I was asked.
isn't that in dispute? I mean, as I read the brief of the other side, they questioned whether, I forget his name, was the general counsel of the company, outside counsel.
Bruce Scar. They submitted no affidavit on that subject, Your Honor. The only evidence that you have is that he was the outside general counsel, and that's how he was represented to me on several occasions.
Do you think, I mean, ultimately you brought a claim against Kim Abrano and maybe Frank Abrano, was he also a defendant? Okay.
Yes, he is.
And you've got a Wage Act claim against her, I assume.
That's correct, Your Honor.
I guess wouldn't it, if you didn't have this problem, wouldn't the company have been a natural defendant in that action?
Oh, Your Honor, no. The plaintiffs in that action, Bryan and Bridget, made a choice. They could either pursue the company for the Wage Act, or they could pursue the person who controlled the company as is permitted by the statute. They own 49% of the company. It's not a difficult call to make to say, I'm going to pursue the person who's actually responsible for this, Kim Abrano, as opposed to the company where essentially I'd have to pay myself 49% of the resulting judgment. So there's no suggestion, there should be no suggestion that somehow it was done to avoid a conflict.
Could we talk about your definition or your understanding of what directly adverse means? I'm looking at comment 6 under Rule 1.7A1, which says, absent consent, a lawyer ordinarily may not act as advocate in one matter against a person the lawyer represents in some other matter, even when the matters are wholly unrelated. So wouldn't that establish the conflict right there?
No, Your Honor,
where
because
you undertake to represent Bridget and Bryan, and you already represent the company in the Waldman matter.
Your Honor, that presumes that there's some adversity on July 1, and there was none.
No. The rule defines directly adverse to be the situation where you represent the company and you represent somebody who has a claim against the company.
But I was not retained on July 1 to pursue a claim against the company. I was retained on July 1 to see what these individuals could do about the interference of Frank Abrano.
Yeah, and that interference was the direction to Kim not to authorize the payment. I mean, that was what was really churning this thing, right? The fact that they didn't get paid.
That was the most recent incident, Your Honor. Absolutely.
Yeah.
But that was not a claim against the company. The company had actually issued the checks, had the money in the bank account. Let me put it to you this way, Your Honor. If the company had issued them the checks and someone had taken those checks out of the mail and kept them from reaching my clients, that would not be a claim against the company. That would be a claim against the person who intercepted, who interfered. So in point of fact,
you've got a Wage Act claim. Your Wage Act claim is not against the individual, it's against the company.
the Wage Act did not come up in this situation at all until July 15th, when Kim Abrano said, "You are not getting another dime." That created the conflict between the the company on the one hand and the individuals on the other hand. At that point, the rules required us to withdraw. And we withdrew from the representation of the company. And then the rules also say at that point, whether you could continue to represent anyone is then determined by Rule 1.9, which is the successive representation rule, in which you judge whether the matters are substantially related. The matters were not substantially related, as everyone here admits. So, Your Honor, the adversity was driven by the actions of the company, and once that arose, we did what the rules required us to do. Thank you very much.
Good morning, and may it please the court. I am Euripides Dalmanaris, and with me is Carolyn Donovan.
Well, why isn't what Mr. Yurko has described just right?
Because the facts don't support what he just described. And here are the facts that were before the Judge Sanders when she correctly disqualified Mr. Yurko's firm for violating Rule 1.7 as well as Rule 1.9c in the alternative. We know, based on the admissions in the complaint filed by Bryan Abrano and Bridget Rodrigue, that they claimed that as of June 30th, 2014, they were expecting substantial fiscal year-end payments from the company that they alleged that the company was legally obligated to make. Those are their allegations in the complaint drafted and signed by Mr. Yurko's firm.
On what
In
date?
November? That's
In
in
No-
November?
In November.
Okay.
But in the demand letter that was sent on July 21, they make the same allegation. Now, at the
The
time,
company was not controlled by Kim
well,
at that point.
As of June 30th.
as a matter of fact, we believe it was, because she,
Say, I mean, the board of directors were two-thirds not Kim. So
She had no control.
how could Kim be I know she had financial control and ultimately exercised that on July 15th, but if you're working for the corporation, don't you listen to the majority of the board?
well, when you work for the corporation, you listen to the entire board, and you take direction either from the disinterested members of the board or the shareholder. And I want to address your question directly. In paragraph 44 of their complaint, they allege that Mrs. Abrano, as an agent having management of the corporation on June 30th, 2014, stopped payment on those checks. So even though they controlled 2 of the 3 seats of the board, clearly Mrs. Abrano, exercising her power as a majority shareholder and as a corporate agent, stopped payment on those checks. And which begs the question, how could they have controlled the company if Mrs. Abrano stopped payment of
Could
those
have
checks?
acted without authority.
Yeah.
Oh, no, they allege that she was an agent having management of the corporation. It is in paragraph 44
But I
of
mean,
their complaint.
okay, so maybe the bank, maybe she's listed on the bank as a person who
Yeah.
has the authority to do that, okay? So why is that so important?
Because she had control and she was acting in the corporation's best interest.
She's not she's not the CEO, right?
She's the director and she is
Right.
the majority shareholder.
Right,
And she is-
but the majority of the board is not she.
Correct, but there wasn't a board vote. I mean, this wasn't a case where all 3 directors
Where
got
was
into a room.
Where was the CEO at this point on
He
this
was-
issue?
He was not consulted, as far as we know. He was not consulted. He took no position on these matters.
So a director takes direct control of a corporate matter?
The majority shareholder,
That may be, but she's acting as a director, you're saying.
correct. And if the allegation,
In an operational capacity, the director's acting in an operational capacity.
as well as the majority shareholder in a closed corporation, yes. And by the way, as a majority shareholder, she owes donahue duties to the company.
Well, so do
And
they.
she, correct. And she was acting in what she believed was the best interest of the corporation.
But that doesn't,
Okay, so, I mean, well, so let's put aside what happened before July 15th, okay? Let's assume, for the sake of argument, you're right, and they
Yeah.
should have done something differently.
Right.
Why are you harmed now by their representation of these two individuals?
Because the corporation was due an undivided duty of loyalty by YSR.
And that's
Oh,
the,
you're saying back, I'm sorry, so you're saying that there is nothing now that you're harmed by, but you're saying because they did something bad between July 1st and July 15th, they should not be allowed to represent these two individuals?
Well, there's additional harm. First of all, the breach of the duty of
I'm sorry,
loyalty
so
is
is your
harm in
argument,
itself.
but
Correct.
I'm trying to separate the two. I mean, the 1.7 says they were in conflict, and if the judge relied upon that, the judge is saying, okay, there was at one point a conflict, and therefore I'm going to punish them for that conflict by not allowing them to represent these individuals. Is that your argument?
That's part of it. In addition, 1.7 includes a duty of confidentiality.
Okay, and how is, I mean, are you, okay, well, let's focus on 1.9 now.
Sure.
Are these, is the Waldman matter substantially related to the matters before, right now before the courts?
No, and under Rule 1.7 and Rule 1.9C, that is not relevant.
It's not substantially relation, it's not relevant under 1.9?
Not under 1.9C, Your Honor. And as you
Okay,
wrote in New
under
England Pro
1.9
Tour,
I understand that, okay, so 1.9C indicates that even if it's not substantially related, there is a danger of a breach of confidences obtained during the course of the representation of the company. Are you claiming that there's confidential information that they obtained during the representation of the company which now poses a risk of harm to you?
yes, and we argued that below, and I believe the record supported Judge Sanders's finding that Rule 1.9C in the alternative was violated.
And help me to understand what that risk meaningfully is.
Excuse me?
Help me to understand what that risk of what they learned during the Waldman representation is going to arguably harm the corporation now if they were to use what they learned during the Waldman dispute.
Well, Comment 3A to Rule 1.16 defines confidential information to include information learned during or relating to a representation. We're not alleging that the confidential information that they have used and would use against my company was learned, was related to the Waldman litigation. What we're asserting and what the record shows was that they got this information during their representation in the Waldman case. And it-
But does it not matter in that regard that the two clients, who are the majority of the board, have access as shareholders and as board members? They've got access to that information, don't they?
They may have had access to it, Your Honor.
And they
but
can't share it?
They cannot share with the company's lawyer in order for the company's lawyer to develop claims against the company. And that is what happened here.
Well, but it isn't against the company.
On July 21, they sent a demand letter to the company asserting Wage Act claims against the company and threatening to report the company to the state and federal authorities. And while the company was not named as a defendant in their complaint, the body of the complaint refers to the company as Defendant Bryan Corporation. And we don't believe that was a Freudian
why
slip.
wouldn't they have learned everything that they learned in connection with the Waldman litigation about the company, simply to learn it about the company? I mean, it was a company at that point controlled by these individuals, Abrano and the sister, right? Brian and Bridget.
Who,
At the time that
yes?
the Yurko firm learned the information that you're saying was confidential to the company,
Yes.
they learned it from Bridget and Brian, who were in control of the company. So they were pretty much, so, I mean, so they should, I'm not understanding what's so harmful about this information.
Because that information wasn't provided to the Yurko firm in connection with the Waldman litigation. It was different
How
information.
do you know that?
Because it's evident from the face of their demand letter and the complaint. They're making allegations about the company's corporate financial, tax, and compensation practices going back to its founding in the 1980s.
You learn all kinds of things about a client in connection with litigation.
They have not made that allegation. And there are no facts to support that. They learned this information in connection with the Waldman litigation. This information was collateral to the Waldman litigation and was provided during the Wallman case for the express purposes of developing claims against the company, among others, and that was a violation of Rule 1.7.
Well, presumably now Bridget has her own counsel, not represented by Mr. Yurko, right?
Correct.
So the same information is presumably known by that counsel. So where are you
Presumably.
going with this? I don't understand your point, other than to just get rid of an inconvenient opponent.
Well, that is not the point. Any firm can seek to circumvent Rule .19 or 19C, or for that matter, Rule 1.7, by saying, look, the information that I have and I want to use against my former client is not privileged, it's only confidential. It would come out in discovery regardless. If some other law firm can use it, why shouldn't I? That's not permitted under Rule 1.9C or 1.7.
Same people who told it to me are now my clients. They told it to me when I was representing the company because they were aligned with the company.
They were not.
Told it to me, they could have told me the same thing afterwards. I mean, because they're the same people and know the same information.
They were not aligned with the company. They're asserting Wage Act claims as of July 1. According to paragraph...
They learned it, they were.
Excuse me?
I thought the point was at the time that they learned the information, they were aligned because the board was not adverse at that point until the change in when the new board was voted in.
They allege, on paragraph 33 of their complaint, that as of July 1, 2014, in fact, they allege, beginning on July 1, 2014, and thereafter, plaintiffs Bryan Abrano and Bridget Rodrigue repeatedly requested that their year-end wage checks be paid to them. They began demanding them on July 1, the same date they consulted with the Yurko firm and the same date that the Yurko firm agreed to represent them. When an employee starts demanding earned wages from its employer, it is by definition directly adverse to the employer. And that direct adversity was ripe as of July 1. And this issue,
Did the judge make that finding?
the record would support that finding, yes.
Well, did the judge make the finding?
I believe she did. In order to have found disqualification
She
under
didn't-
Rule
she just-
1.7, she had to have.
She didn't, am I correct that she basically listened to the argument? She'd obviously read what had been put before her, and she said, clearly there's a conflict and the Yurko firm needs to be disqualified. She didn't make specific findings, did she?
She did not make oral findings or issue a written decree, but we made this argument in our reply brief, and we made this argument at the hearing, and we believe that in order to have found disqualification warranted under 1.7, she had to have made that finding. And with respect to the issue of control of the board, the company was a separate and distinct legal entity. It is still a separate and distinct legal entity. It is distinct from its officers, it is distinct from its directors, it's distinct from its shareholders and its employees. And the Yurko firm owed an undivided duty of loyalty.
Get that, but who are you supposed to listen to? Who's supposed to be guiding you in terms of what you do?
Well, in this circumstances, Rule 1.13G provided the guidance. And a law firm may represent a corporation and its constituents where they're directly adverse if they get the informed written consent of both parties. And 1.13G guides lawyers and directs them that in getting informed written consent, they can't get it on the company's behalf from the individuals who are to be represented individually. And therefore, that disqualified Bryan and Bridget. And what the rule further says, in those circumstances, either you got to go to a disinterested official or the shareholders. And there was only one other disinterested director, and that was Mrs. Abrano, and she was the majority shareholder. So in these circumstances, as of July 1, 2014, YSR was obligated by the rules to approach Mrs. Abrano about this issue. And it's undisputed that they never spoke to her.
Okay, so let's assume you're right. We're talking about 15 days in which they had a conflict.
During those 15 days, they are being funneled information about the company so then they can turn around on July 21 and assert claims against the company and threaten the company with being reported to federal and state authorities. And I just want to,
Being funneled information by the persons who are now their clients.
pursuant to a conflicted dual representation, yes. Yes, we don't,
All right, so
we don't
you're
dispute-
saying that the harm, that what they learned during those 14 days from at that time, the controlling members of the board, who are now their clients, is such that these people should be denied their choice of counsel because the corporation is so harmed by that?
Correct. And I don't believe that their choice of counsel should be given much deference in these circumstances, and I believe Judge Sanders correctly didn't give it too much deference, because here you had corporate insiders co-opting the corporation's lawyer, providing the corporation's lawyer information that the corporation's lawyer then used to develop claims against the company.
Okay, thank you.
Thank you.